What's one question you should never have to answer in a wrongful death lawsuit here in New York? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so let's say one of your family members has died and you, on behalf of your family, have now brought a lawsuit for medical malpractice and wrongful death against this careless doctor. You claim that the doctor violated the basic standards of medical care and as a result caused an untimely death of your family member. It might be a husband, it might be a spouse, a wife, a brother, sister, child. Okay? And now, here's the question. During the course of your lawsuit, you will have to give answers to questions by the defense lawyer, by the attorney who represents the doctor. We call this question and answer session a deposition. It's pretrial testimony, it's sworn testimony, which really takes place in your lawyer's office, in his conference room. Now, there's a big difference between giving testimony there and giving testimony at trial. The main difference is that there's no judge present and there's no jury present, but there is a court stenographer there to record all of the questions that are asked and all of your answers. Those questions and those answers then get put and transcribed into a booklet that we call a transcript. So who is actually at this pretrial question and answer session? Well, obviously you will be there on behalf of the family who is bringing the lawsuit. Your attorney will be there as well. The lawyer who represents the doctor whom you have sued is going to be there, and of course the court stenographer. All right. Now, the purpose of this question and answer session is really to lock you into your testimony. And you should know that the answers you give to these questions carry the same exact weight as if you are testifying at the time of trial. The defense attorney will be asking you lots of questions. It could take all day to ask you all these questions. Now, you should know that many defense attorneys during these medical malpractice and wrongful death cases like to ask one key question thrown in there somewhere about life insurance. They want to know whether the person who died had life insurance. Now, you might think, okay, what's the big deal, whether he had life insurance or not? If he had life insurance, sure, let me go ahead and tell them. And then the next question will be, well, how much life insurance did he have? Now, why is that subject important to the defense? And can they use that information at the time of trial? One of the reasons why the defense wants to learn information about whether or not the person who died had life insurance is because they ultimately want to try and use that information against you and your case. Now, how would they do that? Well, they'll do that in one of two ways. During settlement negotiations, assuming there are settlement conversations at some point during the litigation, they will try and argue, hey, listen, why are you asking us for all of this money? The family already received this amount of money from life insurance. How much more money could they really need? That's an argument that they will try and raise to the judge during the course of settlement discussions. That's an argument that they will raise with your attorney during settlement discussions. And I have to tell you something. That's a very offensive type of argument. You want to know why? Because whether or not the person who died actually has life insurance has absolutely nothing to do with the actions of this careless doctor. It has nothing to do with the fact that if this doctor was in fact careless and this doctor's actions caused this patient's injuries and ultimately his death, well, guess what? Then the doctor is held accountable for all of the harms, all of the damages that were incurred as a result of his carelessness. He doesn't get a discount because this person happened to have a certain amount of life insurance. He doesn't get the benefit of a credit by saying, okay, the family has gotten $1 million in life insurance, so therefore if we're $5 million responsible, we only have to pay $4 million. No, that's not how it works. Everyone is accountable for their own actions. And if in fact the jury ultimately determines that yes, this doctor was careless, and yes, his carelessness was a cause of this patient's injuries, and yes, this patient's injuries are significant and this person died because of all that carelessness, now the doctor has to account and compensate the family for all of those losses and harms and damages that they can now show that they're entitled to receive. Just because you have life insurance does not mean that the doctor has to pay less if he's found responsible. That's what I find so offensive when a defense lawyer tries to ask that question during the course of pretrial question and answer session, and they turn around as a throwaway question as if they're not really paying attention. They're going through the notes. Oh, by the way, Mrs. Jones, how much life insurance did your husband have? What? Objection! Don't answer that question. That's an improper question, and the defense lawyer knows it. And if they start arguing with me, you know what I do? I say, hey, counselor, show me case law that indicates that that's a proper question. Show me case law that my client, the surviving family, has to go ahead and answer that question. Show me how that question and that answer is relevant to your client's culpability and to the damages that he will likely have to pay as a result of his carelessness. And you know what happens then? They back off because they have no case to show me. They have no support, no legal support to claim that that's a proper question. And if they persist, I have every right to tell my client not to answer that question because it is a palpably improper question, and it is my legal opinion that that question should not ever be answered. Now, there is one little exception here. If, in fact, the person who died did have a life insurance policy, and there is evidence of a life insurance policy, there is the possibility that the defense lawyer might be asking that question not to determine how much the value of that insurance policy is, but whether he can get the medical records that were part of the application to get approved for the life insurance policy. There may be an instance or a question about what is contained in those medical records. Now he had to go for a medical examination. He had to fill out certain forms, certain paperwork for the doctor so that he could examine him to determine what? Whether or not he was qualified for this life insurance policy. In certain instances, there may be discrepancies between what he has put down in those medical forms for the life insurance policy compared to information that he provided to this particular doctor whom you are now suing, claiming that he was careless. In that instance, asking that question about a life insurance policy may be appropriate. But that's a very, very limited instance. But the moment they try and ask about how much, absolutely not. That's irrelevant. It's palpably improper. I direct you not to answer that question. So why do I share this with you? I share this with you because this comes up in practically every single wrongful death case here in New York. The defense attorney is told by their superiors, hey, listen, try and get this question in, try and get an answer to the question. Maybe we can use it during settlement negotiations. Maybe we can also use it to get that in front of the jury somehow. And that type of tactic can be employed, but it's going to backfire because all of these objections will then arise during the course of trial, and in all likelihood, if it involves an amount of money that they're trying to get in front of the jury, guess what? In all likelihood, the judge is going to turn around and say, objection sustained, counselor. You know that's not appropriate. The jury is to disregard that question and has nothing whatsoever to do with this case. So they run the risk of getting yelled at and castigated in front of the judge, in front of the jury, and that's not a risk that many attorneys are willing to take. You know, I do realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but are thinking about bringing a case, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.